What's up, everybody? Bunch of new Kohberger documents people have been asking about. So we're going to take a couple of them here right now. One is going to be the state's motion to reconsider the staying speedy trial, adding those 37 days. The state does not agree with the court's decision. So they're asking the court to reconsider its decision and its order. Nothing wrong with that, but they just have further argument they want to make before that decision is finalized. And then they also filed a motion for a scheduling order, which basically means, Judge, we need you to decide when all this stuff is done, especially if with the stay. Is that going to extend any periods of time for any of this stuff to be done? We want you to start setting that stuff up so that if the defense delays, then we can attribute that delay to the defense, and therefore we don't have to be held in the speedy trial period. Additionally, maybe the state wants to try this case in October because they are ready. So they're saying, let's set these deadlines, make sure the defense does everything they need to do, make sure they know what they need to do so that there's not any issues or complaints later. Let's get this stuff on the calendar when it's due. And if they're late, we're going to hold their feet to the fire. If they miss deadlines, we're going to object and not let them just delay unless they want to waive speedy trial, potentially to ask for a continuance of some sort. So those are the two documents we're going to focus on today. Hit that like button if you guys haven't already for this Kohberger stuff. So many of you sent it to me on Twitter and Instagram. At Tragos Law is the handle there. And I got a lot of these documents to break down. I'll probably do another video later this week breaking down the reply in support of the motion for protective order to still try to block some of that DNA evidence. But for now, let's jump to the motion to reconsider the stay, which I think is an interesting thing for the state to do. It is very unusual for courts to change their mind on motions to reconsider, but sometimes it protects the record. So we have a record of more arguments, because if you think about it, each side has already had their opportunity to make arguments, to file documents, to put case law in there and try to convince the judge to go their way. You don't file a motion to reconsider unless the judge didn't go your way. So it's almost like an appeal, but not quite. But they are asking the judge to reconsider his decision here. This comes down to the state asking for the judge to reconsider. The law does not allow defendant to partially waive his statutory right to a speedy trial, and thus his acquiescence to the limited stay in this matter could be deemed a full waiver of speedy trial, with the potential to create needless litigation in the future. Additionally, the court's stay has no practical effect where A, the parties are continuing to litigate discovery matters and file motions, B, trial remains set, and C, the defendant is free to request a stay in the future. Due to these practical considerations, the state respectfully requests this court rescind its order staying time for speedy trial. The state further requests that the jury trial in this matter remain set for October 2nd, 2023, or alternatively, that it be moved beyond the speedy trial period only if the defendant unambiguously waives his right to a speedy trial. The state makes these requests to give the parties, the victims' families, and the witnesses predictability as to the future trial dates, to protect the record, and to avoid needless speedy trial litigation down the road. So what do they mean here? We talked about this a lot already when we saw the judge's order, that the state could try to argue later that this was a continuance or a delay attributable by the defense. But we said it was probably cured based on the judge's words and the judge's ruling. Now, just because a judge rules a certain way does not mean that's how it's going to end up, because the state could be saying, Judge, we realize what you said in that order, but that is not what all the case law says. Number one. Number two, you're setting a bad precedent allowing defendants to request temporary stays, which are literally the same thing as continuances, but acting like the speedy trial rule doesn't apply. Next, even whatever you just put in your motion, Judge, does not prevent the defense from one day after their speedy trial period ends, but within this 37-day stay, from them filing a motion saying, you have violated our right to speedy trial, and then we're going to have a whole litigation. So some pretty decent arguments by the state that will really depend on how the judge reads the case law. Does the judge think he has authority to do this? I think he does in limited situations. I think he protected the record enough in his order, but it's an interesting practical argument made by the state here. Background, we know it was charged, filed motions to stay the proceedings, intending to contest the indictment on July 10th. The judge issued the order with a limited stay of proceedings. The court elected to issue this limited stay to toll speedy trial, relying upon the good cause language. As the court noted in its order for a limited stay, counsel has agreed to those terms and that they could not later argue that his right to a speedy trial was violated. So it does sound a little bit like something was waived by the defense, right? And I think that's what the state's trying to say. Sounds like it was a waiver, but it's not unambiguous. So we need it to be unambiguous, which obviously the defendant is not doing. So that creates some issues. All right, let's hear the state's additional argument. This Idaho code, which allows a court to dismiss a case for lack of speedy trial, is triggered if a defendant whose trial has not been postponed upon his application is not brought to trial within 6 months from filing an indictment or information. Notably, it does not require an unequivocal, on-the-record waiver of speedy trial. Instead, the statute by its own language excludes from relief those individuals whose trials have been postponed upon their own application. State versus Lundquist is instructive. There, the Idaho Supreme Court held that an individual who requested a single trial continuance beyond the speedy trial period in order to substitute counsel but objected to further continuance had fully waived his right to a speedy trial. It's exactly what we said. Technically, this could be a delay attributed to the defense. Therefore, did he actually waive his speedy trial here as part of this stay? A Lundquist arraignment took place on January 4th. On April, trial was set for July 9th. On April 18th, Lundquist filed a motion to separate his trial from that of the two co-defendants. The motion was granted on May 31st because he had not waived the speedy trial right, while the co-defendants had. Same thing that happened in Daybell and Vallow. On June 14th, 1996, Lundquist moved to substitute a new attorney in for one of his two defense attorneys representing him. The court determined that Lundquist would be allowed to substitute counsel if he agreed to a continuance of his trial and waived his speedy trial right. Lundquist and his counsel had concern Lundquist could be tried with his co-defendants in the future if he were to waive speedy trial. However, the court noted that the co-defendants were not prepared to proceed to trial and had requested a trial continuance. Whereas the court could set Lundquist's trial earlier in August or September. So the co-defendants weren't ready even in August or September, so theirs was already pushed out to January, so it would be unfair to Lundquist potentially to rope them all in together, so he could still waive a speedy trial right, but set the trial in August or September. Lundquist then agreed to the continuance and waived the speedy trial right. His trial date was continued to September. On August 5th, the state moved to continue the trial in order to prepare a response to a report from a defense psychologist. Lundquist objected to the continuance, arguing that the state had time to prepare. Lundquist offered not to call a psychologist if it meant that there would be a continuance. So again, he's saying, instead of granting this continuance, can we please just get rid of this expert potentially? The state made a motion to consolidate Lundquist's trial with that of his co-defendants, and the motion was, nevertheless, the court granted the state's continuance. Then the state made a motion to put him back with his co-defendants, and that motion was granted. Ultimately, Lundquist's trial did not start until January. A year and 25 days after he was arraigned on appeal, Lundquist did not consent to the continuance. Did not contest the continuance from July to September. Instead, he argued that the subsequently granted continuance from the September trial date was in violation of his speedy trial rights because his waiver was limited to the initial continuance. So what happened here? The defendant didn't want all this bad stuff to happen, but wanted to be able to use his expert, so he had his expert. When the state needed a continuance to combat that expert, he said, I'll get rid of the expert. The state said no, the judge said no, we're going to grant that continuance. Seems totally unfair. But once you waive your speedy trial rights, if it's even a little bit reasonable that the other side wants a continued trial, usually the state or the court is going to grant that continuance, which happened to Lundquist, screwed him by bringing back with his co-defendants, which is the whole point of what he didn't want to do in the first place. Seems totally unfair, but does happen. That's why that speedy trial right is incredibly important. Idaho Supreme Court unambiguously rejected the notion that the defendant can partially, but not fully waive his right to a speedy trial, explaining that the section does not allow for such a limited waiver. Once the trial has been postponed, the 6-month statutory period no longer applies. So what do we have here? We have a situation where it was temporarily delayed. But we do not have a situation where the defendant has waived, it is delayed, but the defendant has not partially waived, at least by their argument and by the court's decision. that they have not waived at all, not unambiguously, not partially, not at all. In this case, here's what the state argues. The court issued its order for stay after defendant requested a stay, which, as the court noted in its order staying time for speedy trial, is a premature request. So they shouldn't have even granted it because it's not the right time. But the fact that they asked for it is potentially them asking for a continuance or a delay in the trial, which I agree with logically. Instead of issuing a stay under Idaho Code 2213, the court crafted a limited stay that serves not to halt the proceedings in the traditional sense of a stay. We talked about that. It's not halting discovery or motions or depositions, but rather simply to extend the speedy trial period for 37 days. However, the trial was left set for October 2nd. So it's like only if we need those days, basically. Although the defendant may have stated on the record that he did not intend to waive a speedy trial, the practical effect of his motion for stay and the court's subsequent order is that the court has issued an order upon the defendant's application that the trial may be set outside of the 6-month speedy trial period. Got to be honest, sounds like they listened to the video because it's exactly what we said, that an argument could be made that this is a delay asked for and attributable to the defense. Like literally, it's exactly what we talked about in the last video, or the video about the court's order. If it further complicates matters that the defendant has even stipulated to good cause under the very statute that the Idaho Supreme Court has held cannot allow for limited speedy waivers. This court finds, and Kohberger has agreed, that there is good cause to stay the running of the speedy trial clock for a set period of time. And then again, they quote Lundquist does not allow for a limited waiver of speedy trial. So is that the same thing? That's what the judge has to determine. And I will say, so this is the first time I'm reading this motion with you together. So this is very different than this is very different than your normal or your average motion for reconsideration. They're not making the same arguments. They're basing this motion for reconsideration on something completely new, which is the judge's order. So this is something new. This would have a better chance of overturning a prior argument, although I still think the judge is going to stick with what he already did. But this is different than just a lot of times motion for reconsideration. Lawyers make the same arguments they already made that lost with the judge, which very rarely holds any weight. As a purely practical matter, the parties, witnesses, and victim family members are now in limbo. Will trial be set out 30 days at the defendant's option or not? If the defendant reviews the grand jury materials and elects to challenge them, will the court issue another few-week postponement? Could more few-week postponements be forthcoming as other pretrial matters get litigated, such as 12B motions, 404B notices, motion to eliminate or death penalty charges? The state is respectful of the defense's responsibility and needs to prepare for trial, and specifically the need to review all the documents in this matter or all materials at issue. See, I'm just going to pause here. This is a BS argument by the state, because if he waives speedy trial, I would bet my life the state eventually asks for a motion to continue. And regardless if they do it in this case, they do it in other cases. So they realize that as annoying as this is for parties, for defendants, for witnesses, for victims, it happens in almost every case that there's some reason for a continuance. And the judge always has to balance all these issues. So this is not a new argument. This is not a reason the judge is going to undo this stay, because every delay is an inconvenience to everybody involved. It sucks. We wish there was never delays, especially plaintiffs' lawyers like myself. We hate delays, but it happens in every case. So this is not a good argument. But it is the state who carries the burden of proof in this case, an awesome endeavor requiring the subpoenaing, preparation, and coordination of numerous witnesses, many of whom require travel arrangements and other logistical considerations. These witnesses include loved ones and friends of the victims who are undoubtedly anxious for some degree of predictability as this case proceeds. Like, that's such a joke, because the state is not giving them, the state could make it more predictable for them as well by telling them more information, and they're not. So it's like they're using the victims as a short sword and a shield to me. The state is concerned that should the court continue to order such short-term stays, that these witnesses, not to mention the parties, will be left in limbo during a series of tolling periods where short-term continuances could be invoked at the defendant's option. I do agree that it sets a bad precedent, and the judge should not make a habit of granting short-term stays where the defendant has not waived his right to a speedy trial. I do agree with him there. Conversely, if the court were to consider its order and reconsider its order and determine that it was appropriate to rescind that order, nothing would change. Defendant would still be entitled to review of the materials that are being prepared and provided, The state would still continue to provide discovery. The parties would continue to litigate discovery matters and file motions and responses to those motions. The defendants could still elect to seek a stay when it's actually ripe, and defendants could still determine whether to waive his right to a speedy trial or proceed in October on the currently set trial date within the speedy trial period. Conclusion. As the court noted in its recent order, this is a complicated and unusual case posing unique challenges to all parties. The state is appreciative of the balancing that the court must do in this case and of the court's sensitivity to the needs of the parties. But while the defendant undeniably has the right to review the grand jury materials, the law simply does not allow for a defendant to agree to toll the speedy trial beyond 6 months and later invoke his right to a speedy trial. As such, in the interest of protecting the record in this case, and in the interest of promoting efficiency and predictability in the weeks or months ahead, the state respectfully requests that this court reconsider its order staying the time for speedy trial. I actually think this is a pretty good argument by the state, especially if the judge plans to do this in the future. I think that's inappropriate because you either invoke your right to speedy trial or you don't. And if you ask for delays, you don't. However, it seems like the court thinks this is a little unfair and that the state may have caused some of the delays, necessitating the defense to get more time to review these documents. That's where they came up with the 30 days. And that's why the court set it out for the indictment period, not discovery, motions, depots, stuff like that, like a normal stay might. So we'll see what the court says. I'm really interested I think the court's going to deny this motion to reconsider. I think the court's going to go ahead. And what's also interesting about this is it's not as scary for the judge because this isn't going to become an appellate issue. If they go to trial and the defendant wins, the state's not going to appeal or be able to appeal because of double jeopardy. And if you give the defendant a little leeway, it's not going to have a negative effect on the appellate issues. So we'll see. Now, it could become an appellate issue if the defendant says, oh, you waited until after the speedy trial to try us. It could become an issue there. So that's really the only thing the judge would have to worry about staying the motion is that the defendant would later argue that within this 37-day period, but outside the 6 months, hey, this is violation of my speedy trial rights. I think the judge would shut that down quick, and I don't think that would ever win on an appeal because everybody knows what they're doing at this point. Okay, let's now get to the scheduling order here. All right. So this is a motion for scheduling order, which is just the state basically asking the court to set deadlines. What deadlines without limitation do they want? Deadlines for the completion of discovery, deadlines for parties to make expert disclosures, deadlines for filing of pretrial motions and responses and replies thereto, including but not limited to motions in limine, motions relating to the death penalty, and any motions under ICR 12B. Deadlines for jury questionnaire proposals, deadlines for proposed jury instructions, deadlines for proposed witnesses, deadlines for Rule 404B notices, dates for pretrial motions to be heard, any other matters to facilitate the orderly progress of this case going towards trial. Because of the procedures mandated by Idaho Code 192515, the scheduling order must necessarily include trial on the issues of both guilt and sentencing. In support of this request, the state notes that the trial is scheduled to commence in less than 3 months, and it is necessary and proper that the parties and the court have realistic scheduling deadlines to address potential pretrial issues. If you guys have any questions about specifically what this stuff is, maybe another video to kind of dive into those deeper. But for the purposes of this, what the state is doing is trying to push this trial toward the beginning of October. Let's get it done now. Let's get it done right. Let's set all these deadlines. Let's make sure everything is done appropriately, because we don't want there to be delays because things aren't done. We want to hold the defendant's feet to the fire because they've demanded a speedy trial. And if they are going to ask for delays, we want that to be a waiver of speedy trial so we can get it on a normal track like we handle in all of our cases. Couple very interesting motions to me filed by the state and how they're handling this case. But I want to know what you think. So let me know in the comments what you think about this, what questions this pops up, and what other documents you might have questions about that have been filed recently. But for now, that's all I've got. Hit that like button on your way out. I'll see you guys on the next time. Thanks for watching another episode of The Lawyer You Know. If you enjoyed the episode, please hit the thumbs up and share with your friends who may be interested here on YouTube. And don't forget to subscribe. You can also follow us on Instagram, Twitter, Facebook, and TikTok at Tragos Law is our handle. And don't forget to listen to the Lawyer You Know podcast featuring new episodes every week. If you have a case you want to talk to us about, if it's a personal injury case, wrongful death, catastrophic injury, car accident, or slip and fall case, please email us at lawyeryouknow@gmail.com. And of course, all these links I just mentioned are included in the description below on this episode and every episode. So until next time, this is Peter Tragos, the Lawyer You Know.